Hi, inventors and creators. So in this video, we're going to talk about design patents, whether or not you should file, what do they protect. We'll show some examples just so you can really get a good idea of whether or not a design patent would be the proper way to protect your intellectual property. Hi, I'm Jason Rosenblum, intellectual property attorney, patents, copyrights, trademarks, and we protect our clients' products and brands from getting ripped off. So this is going to answer some of the common questions that clients ask when they're determining whether or not to file for a design patent. We'll walk you through some examples. Also just show you some strategy on how best to file. So first you really need to understand is what does a design patent protect? So a design patent protects the ornamental appearance of an article, its shape, its configuration, surface ornamentation, how it looks. You'll see in some of the examples that even includes graphical user interfaces, such as iPhone icons. It could be computer screens, how things look on the computer screen. You need to understand that this is all viewed within what's called prior art, meaning everything that exists. So your design needs to be something new that never existed before in order to be granted a design patent. And another key thing to know is that with all patents, whether it's utility, how things function, or design patents, is as soon as you go public with it, or as soon as you make your first sale of that product or disclose it publicly, whether through a blog post, through a investor meeting, something like that, that starts a clock ticking of when you have to file a patent. So you should act quick. In fact, you should try to file it before you ever make the invention public, make the design public, or try to sell it. And you have to be careful because sometimes even if you're having a third party create it for you, there's potential that could trigger a sale there. So with that in mind, let's just take a quick look at one patent just so you could see what one looks like. So this one here is for the screen, like I said, graphical user interface for the original iPhone. This was one of the patents that Apple used against Samsung that they were successful in winning on their claims of infringement of Samsung's phone. So it's good to see that. But what I'm also going to show you is a little bit of how they got to this point, how they got this registered patent. If we just click here, we can actually see the I'm going to show you how we got to this one. Sorry. So as you can see, a design patent, it has a description that determines what each of these images are, but it's all about the figures. The figures are key in a design patent because that's the design. It looks at what the aesthetic aspect of the invention is, and that's what's protectable, not how these keys function, not what's behind it that makes it pop up like that, but just the fact that it looks like that. So we are going to look deeper into how Apple got to this point in their patent here, because there is some strategy behind it that you'll see. But we need to talk about what is infringement of a patent, because when you're deciding whether or not to file one, if you don't know what infringement would be, then why file one? So infringement of a design patent is done under what's called the ordinary observer test. What does that mean? So the ordinary observer states that if an ordinary observer giving such attention as a purchaser usually gives would be deceived into thinking that the accused design is the same as the patented design, then the actual accused design infringes the product. Basically, would be most of the times done by a jury trial. It could be done by a judge, could be the trier of fact as well, and he'd look at the two items, and it's let me correct myself, because it's not even the item. He'd be looking at the patent. Here, in this case, here, and if you remember what the original Samsung phone looked like, which I actually had both the original iPhone and then the Samsung phone, and I right away thought that this would be an infringement, and it wound up being. You would look at what the design application, the registration shows, and then what the product that's being accused, and you'd compare those. You wouldn't compare the actual product that Apple had. You'd only compare their designs that are within their design application, that are in their design registration, I should say. And you look at everything else that's known out there and look at all the differences to see how, what did Apple create that did not exist before? And then what did the infringers or accused infringers device use of that? So that's how you need to look at not only what you created, but what else was out there in determining how much of a difference, how unique is what you created to determine if it's worth filing. And then once you have that, that's when you have to start looking at what are the drawings going to be, because they're such a key part in your design patent application. And we're going to go into that. Now, what are the key parts? So as I just said, the drawings. I mean, they show you that what everything is. That's where it is. It's possible to use photos or color versions, but generally not recommended because sometimes they can be narrowing. The general best practice is to use the black and white line drawings that are usually done by a patent draftsman. Sometimes clients are able to, through their own CAD designs and working with their own team, come up with the proper drawings that we would use. But in most cases, it's best to use a patent draftsman because they know what the patent drawings should look like, and they're best able to capture it in a way that will help you down the road should there be an infringer. The next thing that's really important is the title itself, because that kind of gives you what does this fall into? What does this product you're claiming fall into? And in a way, it does limit what the scope of that design patent covers. If you say it's for a chair and then someone uses it for a bed, that might not be covered by it. So you might want to say furniture instead of chair or bed, so that it gets a little bit broader. There's a lot of figuring out what the proper title is. And then the claim is basically, I claim the ornamental design for, and you list, generally what the title is, that product. What is that article of manufacture in there? And then you'll see that there's a number of different views that you usually put in, because I said the drawings are the most important part. So I'm going to take you back to here just to show here, claim the ornamental design for a graphical user interface for a display, screen, or portion thereof as shown and described. And then the title here, graphical user interface for a display, screen, or portion thereof. And that's pretty much any screen. This one is for the keys. So this one's an animated graphical user interface for a display, screen, or portion thereof. And then in the claim, you have the ornamental design for an animated graphical user interface for a display, screen, or a portion thereof as shown and described. And just to run through quickly, you have a couple other things. Here's one for a bottle. Here's for a chair. And you'll see the title is chair. And then we have also some Nike ones here. So here's for a shoe. When you are filing for the design patent, as you can see, there are a number of different views. And you can put in as many as you want. And one of the tricks that we use is something that I saw Apple did, and that's why I wanted to show you about that registration is when they filed one of their design patents, they put in, so these are the figures here. If you remember, this looks familiar because it's part of this design patent. That's what's claimed there. But here, You see figure 1, figure 2, figure 3, figure 4, it shows how the key changes when you press on it. That is part of this figure here. But here it's figure 182, 183. This application has over 200, I think in the end it's over 300 figures that have all the different icons, all the different screens of the original iPhone. But what they did was, because you can't, within a design patent application, you can only claim a single invention, which in the case of design is a single design. You can't claim all of these, but this strategy, what it does is allow them to file a single application at once. What you normally do then is either the examiner will come back to you and say, hey, in this case, it would probably be about 300 different inventions, if not more. Okay, so they have over 400 different figures here. It looked like the examiner will either come back to you and say, hey, you have this many different inventions. You have to pick which one we're going to review. Or before the examiner even reviews it, you can ask for those to be withdrawn. That's generally the procedure that we like in most cases, especially if you have different designs that are very similar looking, because it will help you later on should there be an infringement. Because if an examiner says, hey, figure 2 and figure 3 are different inventions, and you only proceed with figure 2, and then at a later date someone infringes on figure 3 but not figure 2, it's already declared that that's a separate invention and it wouldn't be infringing. So we would prefer not to have that. So what we do is we ask them to withdraw those first. And this is a way where when a client has a lot of different versions, or the other thing to note is, as you can see here, you have solid lines, like these icons on the screen are solid, and everything else is dashed lines. What that means is the dashed lines are not part of the claim. The only thing being claimed here is that there's icons laid out like this. So in some cases, you might want to protect all the different ways, because it gives you, different protections based upon when you're comparing it to what the infringer's device is. I'm just going to show you some other views in different types of patents, because when you look at other types of products, you're going to see all the different views. Here you can see, a front perspective view is going to be figure 1, side view, opposite side view, front, rear, top are the different. So it's the perspective view, side view, the opposite side view, the front, the back, and then the top views. And in these, as you can see, this is all dashed out, that's all broken lines. So they're really just claiming, this kind of pattern here. And I believe this one was actually one that had a color photo or something. So you can actually ask the USPTO to see what was that color. They don't print up certificates in color, so you can't really see it. Similarly, here's a pair of Nike pants that they give all the different views of it, so you can see it from every different angle, because that's what they're protecting, is that look of those pants. And then here's another shoe by them where they're just only looking to protect what this patch is here. And again, this one was one that had, I think, colors or photos that they don't print on the certificate, but you can ask for those to see what it was if you were concerned that you'd be infringing on them or something like that. But they're not claiming any specific shape of the shoe here. So this could be the side of any type of sneaker, not just a cleat. It could be a regular sneaker that has that side that could potentially be infringing there. So that's, some of the different views, some of the different ways where you see that it is a very specific invention, one invention per registration, which could be one design, but the way to try and protect multiple designs is to file them all together and just parse them out. And then so long as you file what's called a continuation or a divisional of those, you can keep doing that in succession to kind of spread out your fees for all the different filings. You just have to make sure that you have an application that is still pending while you do that, essentially before you pay the allowance fees. And talk a little bit about the procedure. So I already kind of mentioned the continuation applications or divisional applications. That's when you're when you file maybe 20, 30 different image figures and pull out some of them to be reserved for a later date. So once you decide on, what it is you're going to protect, what you're going to file for, getting the figures put together, and you actually prepare, finalize and file the application. There's a number of documents that need to be filed with it. As you can see in this one here, you file the drawings, the claims, the specification, all of these things here from, down here were all filed on the same date, essentially, although, that's the filing receipt for it. That's automatically generated. But just, you can see it's a long process and takes time. Usually there'll be one back and forth with the U.S. Patent and Trademark Office about something in a design patent, assuming the drawings that originally submitted were acceptable. They have very specific rules, which again is why we always suggest using an actual patent draftsman to draft them. The filing fees, you're looking at about 1,000 current fees are 1,020 for a regular, 408 for a small entity, and 204 for micro entities. And there's different, rules what make you fall into small or micro or regular. Once you get through the examination process, they allow it, and there's fees for the allowance, which now are currently $740 for a regular entity, $296 for a small entity, and $148 for micro entities. Depending upon what design area yours falls into, it could be anywhere from a year after you file to 2.5, 3 years. It just depends upon a number of factors. Currently, there are no maintenance fees. And then one of the keys is the enforcement. No one else is going to enforce your design patent other than you. Same thing goes for all patents, for trademarks, for copyrights. You as the intellectual property owner are the one that has to enforce it. You have to police it. Now, USPTO should reject similar applications if they're obvious, both for any type of patent or even for trademarks. They also do a search for likelihood of confusion, slightly different standard, but they should reject them. But that's not the same thing as policing it. That doesn't mean that someone's going to stop using it or making that invention. So that's something you have to do and realize that going into it, that if you're not going to consider that, then there might not be any point in filing the design patent in the first place. Difference between offensive and defensive strategies that could be discussed before doing that. So I hope that this was helpful. It's just like a quick rundown of some strategies for filing a design patent application, what's involved, and just show some other images here. This was a chair. So as you can see in this chair, they use the dashed lines for this portion here, meaning, it could be like those old school chairs that just have like the little line straps across it, but mainly the main part is that frame there that's being protected by this. I think here's another chair one, which, looks like they're protecting all of this top part, but then they are not protecting the, they put in dashed lines at the bottom, so it could be stationary, it could have wheels, it could have other types of wheels, but you'd have to look at this in connection with every other chair that's out there for comparing it to an infringement. How exact does it have to be to this for it to be an infringement would depend upon all other chairs that are out there. My guess would be that this is probably a very narrow patent, meaning if you make minor changes to it, you can get around it, just because there's so many different chairs out there and so many chairs that look somewhat similar to this one. Maybe this is the most unique part here, how this is that little extra piece down there, which if they wanted to, they could have put everything potentially in dashed lines and just tried to protect just that little extra piece that's sticking out there. But yeah, just that little piece that's sticking out there, because that maybe is more unique than every other chair that's out there. So if you like these, please like it, click subscribe, and thanks for watching. Always feel free to reach out with any questions. We're at 888-666-0062, or reach us at jhrlegal.com. Thanks.